This week's reading focused on the rule of law, and more specifically how its interpretation relates to particular indigenous groups. More than this, however, all of this week's readings serve to illustrate how the rule of law can be interpreted in various ways, and even in certain circumstances skewed to best fit the purposes of the person interpreting it. Beginning with the article by MacDonald, the major question to consider when reading is to whom should a practitioner of public policy be ultimately accountable? MacDonald feels that the personal accountability that civil servants and lawyers should strive towards, although he acknowledges that a balance should be struck between personal and external accountability in order for good governance to take place. He also claims that in order to ensure good governance, as opposed to taking the traditional route, which is judicial review, that is having a particular council to oversee a range of issues or the like, but to instead separate the idea of performing due process from the actual ideal of the rule of law. His approach is one that rather puts emphasis on learning from the mistakes made when governing, as opposed to simply highlighting them and coming up with a quick fix that sounds good to the general public. Moving on to the British Columbia versus Imperial Tobacco case, we read about whether or not the Tobacco Damages and Healthcare Cost Recovery Act, which would allow the government of British Columbia to sue manufacturers of tobacco products for costs they incurred while taking care of people who had become ill after exposure to their products. The tobacco company in question claims that the government of BC can't sue them on the basis of three arguments, which for the basis of time I won't go over all of them here, but one of their arguments includes the basis of the rule of law and that this case was unconstitutional. They argued that while the concept of the rule of law may not seem initially relevant to the case, that upon further thought it can be seen as limiting the ability of the judiciary to interfere with the government policy once the act is passed. That is, that it could confer special power to the government, which is against the rule of law. However, this was determined by the court that the act did not breach the rule of law in constitutional terms and as such dismissed the case. Finally, we have the incident involving an illegal blockade by a First Nations group in British Columbia. An oil pipeline which was proposed to extend into hereditary First Nations territory was protested by a group of chiefs of the Aboriginal group who set up a blockade and refused to move until negotiations took place. The issue was taken to court and the RCMP were ordered to enforce an injunction against the blockade, which means that it was illegal. 5 months later, there was no enforcement of this injunction by the RCMP, and when asked why by Judge McEwen, the lawyer for the RCMP argued that in issues such as these, the RCMP required more discretion because the conditions that they would face on the field might incur damages to their personal health and safety that perhaps didn't initially come to the forethought of the judge when they were issuing the injunction. And that is the summary of all three of the articles.